Ah, is everybody here? Good. I think everybody's here. Miss Litvin, is your microphone off? There we go. Good afternoon, everyone. My name is Steve Hill, and I am the presiding judge of this panel of the Kansas Court of Appeals. We are hearing a 1:30 video conference in case number 127-354. With me this afternoon is Judge Tom Malone and Judge J.C. Hurst. We are proceeding with oral arguments on this case. I would ask that appellant's counsel enter his appearance.
May it please the court, Sam Shire of the Kansas Appellate Defender Office appearing on behalf of the appellant, Chad Hartman.
Mr. Shire, do you wish to reserve any time for rebuttal argument?
May I please reserve 3 minutes, Your Honor?
You've got it. Thank you. And for the appellee?
Good afternoon. May it please the court. The state appears by Deputy District Attorney Jody Litvin.
Thank you. We will proceed with this hearing now, beginning with the appellant's counsel. This is a direct appeal, I believe, and Mr. Scheer, proceed.
Thank you, Your Honor. There are a few issues raised in the brief. My plan today is to focus primarily on issue 3 in the brief, the prosecutorial error claim, and touch also on issue 5, the indictment claim. The reason why I'd like to focus on issue 3 is because with that issue, we have a conceded trial error, which the parties both agree requires reversal unless the error can be found to have been harmless beyond a reasonable doubt. So as I see it, issue 3 presents the straightest line to a reverse conviction on the top charge in this case, the electronic solicitation charge. The first thing I'll note with the claim of prosecutorial error is obviously it only comes into play if this court finds that the state has presented sufficient evidence of venue. Assuming that the court does make that finding, I think it would have to concede that Shawnee County was not the most intuitive venue to bring an electronic solicitation charge, given the particular facts of this case. The recorded conversations that happened in this case that resulted in the electronic solicitation charge occurred primarily between parties that were located in Anderson and Harper County. If the electronic solicitation charge had been brought in either of those two venues, I do not believe that we would be here in court arguing about venue today. So to get around the venue problem that's presented by this case in terms of prosecuting in Shawnee County, the prosecution relied heavily on subsection B2 of KSA 222619. That statutory subsection permits the state to bring an electronic solicitation charge in any county in which, quote, the victim resides. In closing argument, the state told jurors very explicitly, in a very straightforward way, that it could satisfy the venue element of its electronic solicitation charge by showing that this case's fictitious victim, someone who does not actually exist in real life, the fact that that person, fictitious person, was said to reside in Shawnee County. Again, the victim in this case, to the extent she does exist, would be somebody who is making conversations primarily in Harper County. There is no real person who resided in Shawnee County.
Well, stop me. Let me stop you for just a second. There's no human being that is the victim in this particular case, correct?
That's correct.
So how can there be venue anywhere?
Venue anywhere? I believe venue is appropriate in any county in which a criminal act occurred. So that would permit prosecution, I think, in either county where communication is occurring. Again,
Where that would be the county in which the phone call was made, or the electronic typing was done, or when it was received. Those
I
are the only
believe
two counties?
I believe both counties, Your Honor, and yes, only those counties in which communication is being conducted.
Okay.
Now, again, the state has conceded that the argument in this case was erroneous, and given that, the question is really, is that error harmless beyond a reasonable doubt? And I think the state has three major problems in terms of establishing harmless error. The first being that the error in this case really was quite consequential. If the jury took the state's argument at face value, it had no choice but to convict my client. The defense in this case was venue. There was no evidentiary dispute that the imaginary victim in this case was purported to have lived in Shawnee County. So if the jury accepted the state's erroneous argument, they were compelled to return a conviction. The second problem that the state has with harmless error is that its evidence of venue is really pretty weak if statutes are interpreted correctly. It would have to be based on a theory that one of the two communicating parties was in Shawnee County at the time of an act that qualifies as electronic solicitation. And the way that the state encouraged jurors to make that particular type of venue finding is by asking the jury to go through a ginormous trial exhibits that spanned literally thousands of pages, and look for a proverbial needle in the haystack. Conversations that may or may not have occurred with someone located in Shawnee County. And I do not believe that jurors would have been inclined to do that, given the testimony in this case. The lead detective in this case testified that he had no evidence that my client or the architect of this case's sting operation was ever in Shawnee County at the time of an act that qualified as electronic solicitation. So the venue evidence, even if it is sufficient, which I don't believe it is, it certainly has to be characterized as a weak case. The last major problem with the state's harmless error argument is that the jury certainly seems to have accepted the state's erroneous argument. And we can see that based on what the jury asked during deliberation.
Tell me about that.
Well, the jury asked the court two questions. One of the questions was, why was this case charged in Shawnee County? That's significant because it shows that the jury clearly had some reservation with the venue element of the state's electronic solicitation charge. The second question that the jury asked, I believe, is even more consequential. The jury asked the court point blank, can we consider Riley to be this case's victim? And the response that the district court gave was essentially yes. The court said, you do not need the court's permission to consider Riley, again, Riley is a fictitious person, to consider Riley the victim in this case. And a very short time later, just 30 minutes of actual deliberation time later, the jury returns its guilty verdict. I think when you look at those questions and how quickly a verdict was returned after the district court's response was given, it shows that very clearly, in my view, that the jury convicted based on the theory that the fictitious victim's residence established the venue element of the state's charge.
Let me ask you this. In order to be convicted under this charge, do you need a victim? Or is the crime completed when the solicitation is made, whether there's a victim or not?
I don't think you need a victim, Your Honor. I think the crime is committed when all the elements have been satisfied. So that would be when you have the criminal act with the requisite mens rea. That's the moment when the crime is committed.
Was there evidence that Mr. Hartman made these solicitations while in Shawnee County?
So there was communication at the very end of the case that occurred in Shawnee County. However, none of those communications were flagged in the state's trial exhibit as communications that constituted a sexual conversation that they were relying upon for a criminal conviction. There has to be an actual solicitation of an aggravated indecent liberties or aggravated criminal sodomy offense based on the way the jury was instructed in this case. And the short answer, Your Honor, is that no, there is no evidence of that. In addition to that, we have an uncertain time in which the architect of this case's sting operation was purported to have arrived in Shawnee County, and that presents another problem for the state in terms of sufficiency. In the state's brief, it's also noted that there may have been one conversation in which Chad indicated that he was in Topeka. I believe there's a reference to Hooten Street, some type of street that's in Topeka that would indicate that my client was in Topeka for a time period. That conversation was not sexual in nature. And it was later stated in that conversation that my client was returning to the yard. In the brief, the state is asking this court to make the assumption that the yard was in Topeka. I do not believe that the record supports that. The yard really could have been anywhere, as there's just no way to tell where the yard was.
Do they need to show that he was actually in Topeka, or do they need to show that he asserts he was in Topeka?
They would need to show that he was actually in Topeka, Your Honor, because venue is established based on the location where an act occurs. And again, to the extent that this court finds that there is sufficient evidence to support a conviction, which again, I do not believe is the case, but if the court found that, we still have the problem of the state's case being extremely weak and having a conceded prosecutorial error that is not harmless beyond a reasonable doubt. And so for that reason, I would respectfully ask this court to reverse the lead conviction in this case, the severity level 3 electronic solicitation charge.
Thank you, counsel. Did that complete your, I didn't want to cut you off there.
I think I've run the course of my argument. Unless this court has any further questions, I will reserve the remainder of my argument for rebuttal.
You certainly have that time. Thank you. Were there any other questions? Otherwise, Ms. Litfin?
Thank you, Your Honor. May it please the court, again, the state appears by Deputy District Attorney Jody Litfin. The prosecutorial error here, appellant's counsel is correct that we have agreed that there was a prosecutorial error that occurred when we are talking about B2, the venue subsection B2, where the victim resides. Our position is that despite the argument that the victim, meaning the fictitious 14-year-old girl, Riley, resided in Topeka, could get us venue, we believe that this is harmless error based on two reasons that there's been discussion about already, which ties us back into the sufficiency of the evidence regarding venue in issue 1. First off, I don't think that the state, I did go back and reread closing argument, and I believe the state made 3 points regarding subsection B1, subsection B2, and subsection B3 of the venue statute and of the instruction that was given to the jurors. And so I don't believe we harped on only where the victim resides could be the only way that we can get venue in this case. So I do believe the prosecutor noted that there were times under B1 where we were claiming that the defendant was in Shawnee County, and there were times under B3 where we were claiming the actual victim in this case, HG, the woman posing to be Riley, was in Shawnee County as well. So our harmlessness
In those times that either the defendant or the victim were in Shawnee County were also in closing tied to specific incidents of violations of the statute?
I believe that's true, Your Honor. I believe that they were talking about, and unfortunately, I have it right here, but I don't have it printed out. But I believe that they were talking about for when the defendant sent text when he was in his semi-truck in Topeka on October 31st, 2022. I don't know if he said the date, but he did refer to the books of text messages. And granted, there are a lot. I'm not going to dispute that there are a lot of text messages. This is a lot of conversations that are happening. But there was evidence that he was in his semi-truck in the Home Depot store in Topeka. He asked her how far away from Walmart she lived, and said that he would stay at the store if she lived close to Walmart. He also made references to the store that he was at was off of Huntoon and Wanamaker, which makes sense because there's a Home Depot store right there at Huntoon and Wanamaker. There's also a Walmart nearby Huntoon and Wanamaker. And then he told her that he was heading back to the yard. And as appellant's counsel said, we are asking this court to make a reasonable, we are arguing that it is a reasonable inference that he was in Topeka at that time and heading back to the yard, presumably at a Home Depot distribution center, which is also in Topeka. There was other evidence with the interview that he gave that the defendant said that he was a truck driver for Schneider Trucking, that his dedicated account was the Home Depot, and that he was in Topeka quite a bit and normally was in a semi-truck. So we would argue that all of this taken together, and then as for the violations, he was sending her a photo of the bed in his semi-truck saying, "I wish that you were here with me," talking about watching movies and kissing and cuddling and that sort of thing. And that's kind of where the acts occur. So we're arguing that on October 31st and then into November 1st, where he also talks about how he was heading back from the store and was done that day. And he did not go home until Friday, presumably meaning in, is it Anderson County, where he lived. And he talked about staying in the semi-truck that whole time. So we're asking this court to take all of that into consideration in the light most favorable to the state, again, to prove venue, and that he was actually in Shawnee County in Topeka, Kansas at that Home Depot at the time that he sent those text messages. The other subsection of the statute, which would be B3, comes from HG's testimony. And although she could not pinpoint exactly when she got to Topeka, there was testimony that she arrived the day before the defendant had planned to pick up Riley on November 15th, 2022. She drove to Topeka late afternoon, early evening, and then during that time, he sent her some text messages about showering together, cuddling, kissing, and that is the evidence that we're relying on for B3, where when HG was actually present at the time of the crime in Shawnee County. So although we're no longer relying on B2 for venue, we would argue that any misstatement of the law or instructional error can be found harmless or not clearly erroneous in this case, based on the evidence that the state presented of B1 and B3. I don't know if I have any other further presentation. As far as, we didn't get into the indictment issue, but also I did want to make one more point, I'm sorry. And I meant to do this when this court allowed me to supplement the record, but just on the indictment issue, I did want to note that the state requested to add the concurrent sheet, is what it's called, from the grand jury. And that has since been added to record volume 15, page 3. And that is just a separate sheet showing that 12 jurors concurred in the indictment. So whether there was a defect in the indictment where the presiding grand juror did not circle that true bill, we believe that this court can take a look at that concurrent sheet, which is signed by the presiding grand juror, and find, I don't know if you want to call it harmless or just no prejudice would be from this defective indictment based on that supplementing of the record of that grand jury sheet. So I did want to mention that since it's not measured.
What you're arguing there is that we can infer that since, what was there, 15 and the 12 out of the 15, which is the majority and that controls, that was, with that concurrence, it's irrelevant whether he marked a true bill or not. Is that what your argument is?
Essentially, Your Honor, yes, you can't show prejudice because we do have another separate document showing that 12 jurors concurred in this indictment. And so the technical, error of not circling that true bill is essentially cured or there's no prejudice from it because we have this other document showing that 12 jurors did in fact concur in the indictment. I don't believe I have any further presentation. We would just ask this court to find under B1 and B3 that there was sufficient venue presented and to affirm the convictions in this case.
Any other questions? All
I,
right,
oh, sorry.
Go ahead.
I did have so I think we're talking about under B1, so maybe 2 days, 1 to 1.5 days of texts. And then under B3, 1 day of texts. And then under B2, it would be a month of texts.
Yes, I mean, I think if we were going for B2 where the victim resides, it would be at her, address and that location in Topeka. That's not a fictitious address, but whatever that address was, I think it would be for the whole time. I think we were talking from around October 6th through, well, October 1st through November 16th or something like that.
Okay.
If that
So
answers your question, sorry.
So the vast majority of the conversation, by vast majority, it's 99%, would have been based on B2 if it were actually legally possible.
I want to say that's correct, Your Honor, because I don't think we have. I think the best evidence is what I've briefed and given in the brief, because I don't think the detective was able to consistently point out any other times, and I don't think HG was able to point out any other times when she was absolutely in Topeka or Shawnee County.
Thank you. I just wanted to make sure I understood. Thank you.
Any other questions? All right, thank you, counsel. Mr. Scherer, your rebuttal.
Thank you, Your Honor. I'm just going to touch very briefly again on the harmless error. And the point I'd like to make there is simply that the lead detective in this case was given the trial exhibit of all the text messages exchanged between the parties in this case and was asked on the stand, please identify any point in which either party to this conversation was located in Shawnee County. The detective testified very clearly that he could not do that. He also testified that there was no evidence of that. So I think that testimony alone, coupled with the questions that the jury asked during deliberations, makes it almost impossible to make a finding of harmless error in this case. I believe it's very clear that the jury convicted based on a finding of venue under subsection B2. Moving to the indictment issue, I think really what we have in the briefing is a fundamental disagreement about how to frame the issue. The parties agree that we have a purported indictment that is unendorsed as a true bill. In its brief, the state argues that this is really a defective complaint type of issue. I fundamentally reject that. I believe that the problem in this case is that there simply is no valid charging document. Since the dawn of Kansas's statehood, courts have determined whether we have a real, genuine indictment by looking at the charging document and checking whether it is endorsed as a true bill. This purported indictment in this case was not endorsed as a true bill. To accept it as a valid indictment would be analogous to accepting a jury verdict that is marked neither guilty nor not guilty. I don't believe a court could do that, and I don't believe that a case can be prosecuted in a situation like we have at bar, where we have a charging document, a purported indictment, that is simply not designated as a true bill. That's a statutory requirement. It's what courts rely upon to determine whether there is a valid indictment, and without it, there can be no prosecution. So I would respectfully ask this court to reverse all three of Chad's convictions and remand this case for further proceedings.
Any questions? All right, thank you very much. Counsel, very interesting case. We will take this matter under advisement And we will adjourn and end our video conference at this time. Thank you.